Department of Innovation and Digitalization at the University of Vienna. It was founded in autumn 2017, and since then we have been working quite intensely on everything which comes with digitalization into the law. On one hand, therefore, we deal in particular with data protection, data security, e-commerce law, consumer protection, copyright, and similar fields of the law, because those are the most prominent fields where the law needs to find answers to everything which comes with digital. On the other hand, we also try to work on everything which changes the law because of the digitalization we are in the middle of. So in particular, everything which is with legal tech related issues is in the field of our interest. And finally, we also try to change and to develop formats of legal education. So we have been quite intensely working on everything which comes with computers and law and education.
Welcome to the Conference of Innovation and Digitalization in Law, aka IDLaw2022. My name is Peter Hubauer. I'm a research associate at this wonderful department, and I have the pleasure to introduce to you today's speakers later on. But first, I would like to ask our deputy head, Professor Dr. Christiane Wenderhorst, to officially open the conference.
Well, thank you very much, Peter. And it's my great pleasure and privilege to be welcoming you this morning to this IDLaw conference. The IDLaw conference is normally put together by our younger generation of researchers, and we're really proud to see what a great program they have again put together. I'm particularly delighted, let me point that out, that they have chosen a very important topic this year. It's the protection of the vulnerable in the digital world. Now, we are well aware that the concept of vulnerable groups has recently come under attack. It's been said to be potentially stigmatizing. It's been said to be potentially inappropriate for the digital world, because in the digital world, to a certain extent, we may all be vulnerable. It may all depend on the particular context and on the situation. But still, it is quite clear that there are certain groups in our society that need our special protection. For instance, minors. Children, young people, but also people generally with limited capacity. And so it's extremely important we look at how these vulnerable groups are protected in the digital world across different legal frameworks and legislations. And so it's important that this protection is A, non-stigmatizing, that it's B, empowering, and that it is C, effective. And so our organizing team, to whom we are really grateful for having put together this program, have invited magnificent speakers that will be looking at precisely these questions, that will be presenting also the results of their research. And I'm really, really looking forward to this conference. Again, thank you so much to the organizing team. Thank you so much again to all the speakers and everybody who's contributed to this. And with this, I would like to hand back to you, Peter, for further introductions.
Thank you very much, Professor Wenderhorst. Before I introduce you, our first speaker, I would like to invite you to ask questions during any time during the presentations via the chat. Our Q&A team will monitor the questions, and they will address them some of these questions directly after each presentation, and continue with the question and answers at the dedicated Q&A session. Now, our first speaker is our colleague, Mariana Alicia Rissetto. She graduated at the University of Buenos Aires with the Argentinian law degree Título de Abogado, which means title of attorney. Further, she holds an LL.M. in International Legal Studies from the University of Vienna. Her research interests include data protection, AI, and new technologies. Since 2019, she has been working on several research projects in our department, one of which is Privacy for Kids, that she will introduce to us now. Mariana, the floor is yours.
Well, thank you very much, Peter. Thank you very much, the organizers of the conference. I'm very proud to be here and also speak on behalf of the project team Privacy for Kids. I think that you can see my screen. Yeah, okay, thank you very much, the presentation. In this time, I would like to introduce the Privacy for Kids project, which in this case, I'm happy to contextualize this topic of today's discussion, as Professor Van der Horst already mentioned, so protecting vulnerable groups in the digital world, with a specific focus of children. And this project in particular is one of the projects that the department is gratefully pursuing since already almost 2 years by now, together with the Austrian Data Protection Authority, Supervisory Authority, with the idea of having a hands-on, fully hands-on project, and with aiming to specifically raising awareness of data protection and privacy issues and challenges to children and young teenagers. When we talk about the project, as aim to familiarize these children of a specific 2 target groups at from the age of 6 years old to the to 14 years old with this topic of data protection and privacy, specifically by materializing this knowledge and bringing to children this knowledge through animated and age-tailored educational videos. With this, we want to explain the importance of the protection of personal data, what the challenges are, what the risks are in the digital world. We're working together with as I mentioned already, with a very good cooperation partner, very successful, which is the Austrian Data Protection Authority, with, of course, the financial support of the European Commission. The project itself is also not only does not only pursue the raising awareness of these topics, but also sensitizing and bringing knowledge to university, also students, so university at our faculty, the Faculty of Law, and other faculties on the matter of privacy, and specifically how these theoretical concepts can specifically materialize into practical ones. Per se about the project, we have already been, we started already in 2021, and the project was divided in 3 specific phases. The first one, we set it up the project by administrative and organizational tasks. One of the outcomes that we're going to see is specifically the website with the content, with the specific tailored content there. The second phase was specifically led by the university, by ourselves, so the University of Vienna, by developing the educational content that was going to be first provided and offered to the students at the Faculty of Law, but not only. And the third phase is the evaluation, the publishing, dissemination, and specifically, and most important for us, and this is something that I also want to encourage the audience, is to provide feedback on one of the outcomes that I will show a little bit sometime later. As I said, we had several project outcomes so far. We had producing the website. We offer a full completed course at the Faculty of Law. We're going to go into detail about the details of the course just a few slides later. And we are currently offering a second course with a slightly different objective and actually outcome. We, and actually not we, but the students of the course have produced excellent 22 videos, both targets, so target for both groups, the first age group of 6 to 10 years old and the second 11 to 14. Together with this, we created a supporting material for teachers to guide teachers teachers in the classroom to use such videos as an educational tool for raising awareness about these challenges and topics that I mentioned before. As well, we're producing certain promoting and dissemination activities, and one specific example and evaluation that we did during the Kinderuni. And it's on the making, and we hope to release it soon, is a card game that I will explain later what is this about. As I was also saying, we provided 2 courses with 40 students approximately each. One of the first outcome of the first course was the 22 videos, and the second, hopefully soon, is going to be the card game. And when we, methodologically speaking, we offered the course in the first course in winter semester of 2021-2022. in a fully, completely online mode. Since, of course, it was at the time, Corona time, I don't need to remind you of this. And in order specifically to go into and emphasize the online classroom and the online tools, we try to provide online environment for students to feel comfortable with, and which is also amicable to them. In this regard, we use, for example, the Moodle, and we put a lot of emphasis on a very user-friendly, interactive Moodle course. Use Discord and offer Zoom as well to interact while in the different phases during the course per se, which was specifically divided into theoretical knowledge learning and practical and hands-on and practical perspective by creating and developing the course. The course was provided in German. This time we had 30 students divided in 11 groups for the 11 topics. And one point that I wanted specifically to mention here is that the course was also provided and offered to students from other faculties, not only law. And when we talk about privacy and data protection and the materialization of these knowledges and bringing this knowledge into children, we need to consider not only the law and the legal concepts, but also how to transmit this message. And for this reason, we invited students from the Faculty of Psychology, the teachers program in informatics and the teacher programs in general, as well as the informatics faculty, where they had these interdisciplinary areas interacting each other. This was also one of the learning outcomes of the learning objectives and outcomes of the course per se, is specifically paying focus on the interdisciplinary nature of, and I would say as a lawyer, of the law as well, and also as we've seen in the department as well, bringing together different areas where we can evolve. The lectures, of course, guided by Professor Fuago. We also had the possibility to have as a lecturer Dr. Andrea Sabadil and 2 colleagues of ours, and specifically also Katerina Bunche, who is an informatics student who helped us in the production of the videos. As I was saying, the students made a very good, excellent work by producing the videos with the support of 2 different tools, which were specifically Doodle and Toonly, and they were writing the script, so the content that they had researched from a legal, psychological, and educational psychological perspective. The content of the videos then transmitted into the script, and this, in order to produce the script, this tool provided to BID, which was developed by Katerina Bunche, was put into action, if I may say that, and helped the students to guide and produce the script in a more targeted way. The videos address 11 different topics, and there are 22 because are divided in the different 2 age groups. If you like to tune in for the videos are already available in different 2 playlists, and also I include the QR code, so you have a little bit of time to watch them. So I think at this point, I would say that it's time to watch a video.
Hey, ich bin Alex. Ich treffe mich gerne mit meinen Freunden vor der Schule, um lustige Videos für das Internet zu machen. Bevor der Unterricht beginnt, lade ich das Video noch schnell hoch.
Alex wartet im Unterricht gespannt auf die Kommentare.
Wow, super cool. Toll gemacht. Liebe es.
Nice moves habt ihr alle.
Schon gut. Cool.
Hey, total tolles Video. Ich glaube, die Schule kenne ich. Wo ist die?
Oh, wirklich? Ja, das ist die Schule in der Wiener Straße. Ich mag übrigens dein Profilbild. Es ist total witzig.
Danke, deines ist aber auch richtig hübsch. Zwischen den beiden entsteht eine Freundschaft. Und, was machst du so? Was ist deine Lieblingsmusik? Wo wohnst du eigentlich? Obwohl wir uns noch nicht so lange kennen, mag ich dich total. Ich bin froh, dass wir befreundet sind.
Geht mir genauso.
Eines Tages bekommt Alex eine ganz komische Nachricht von Magisch34. Ich finde, deine Videos sind cool, Alex. Aber du solltest sie in der Zukunft alleine machen.
Was? Warum denn das?
Naja, deine Freunde sind einfach so uncool. Du bist das da, also solltest du dich nicht mit solchen Leuten abgeben.
Du spinnst doch! Meine Freunde sind echt toll. Lass mich in Ruhe.
Doch Magisch34 schickt weiterhin Nachrichten. Am nächsten Tag fragt Alex seine Freunde um Rat.
Hey Leute, ich weiß nicht, was ich tun soll. Er schreibt mir einfach, obwohl ich gesagt habe, ich will nicht mehr mit ihm reden. Er schreibt dann immer, ich sehe, dass du gerade online bist. Hallo, schreib mir doch zurück. Und es nervt mich einfach so sehr. Was soll ich denn nur tun? Am besten, du ignorierst ihn einfach. Ja, ich finde, du solltest ihn auch einfach ignorieren.
Ich finde es so schlimm, dass du mich einfach ignorierst. Wir müssen darüber sprechen.
Schau aus dem Fenster und komm sofort raus. Ich stehe vor deiner Schule und warte hier auf dich.
Oh nein, was mache ich denn jetzt? Hilfe! Ich wünschte, ich könnte die Zeit einfach zurückdrehen.
Kein Problem, es ist nur eine Geschichte, also können wir das.
Hey, danke für deinen Kommentar, echt nett. Da wir uns nicht kennen, möchte ich dir lieber nicht sagen, wo meine Schule ist. Ich wünsche dir aber noch einen schönen Tag. Es ist deine Entscheidung. Sei schlau und mach es anders. Gib Acht, was du anderen im Internet preisgibst, denn im echten Leben gibt es kein Zurückdrehen.
Great, thank you very much. I think if we can go back to the slides. Thank you. This video was produced for the older group, target group, age group, from 10 to 11 to 14 years old. To the audience here, a request, I would like really to have your feedback on the video. You could also play it again, and we are very happy to receive any comments on the live chat, perhaps after the presentation or during today's event. When following on the next course, and also one of the outcomes of the soon-to-be outcomes of the project per se, we're offering this winter semester a course with a similar methodology but as I said, with different outcome, which is a supporting and complementary tool in this case, paper one, as we are developing a card game in the form of a quartet. Again, issuing and addressing the different topics that we already have addressed in the videos. We, excuse me, we also, as I was saying, we had a supporting material for teachers for the videos, and we intend to produce a digital supporting guidance as well into the card games at the end of the year. And one example of the participation and dissemination and promoting of the project is the participation, so saying, in different videos, different events, workshops, and also the engagement in different schools. In this case, this is only one portrait of the presentation of this project, as well as the videos introducing at Austria governmental level, thanks to the Austrian Data Protection Supervisory Authority. The second one that I wanted to mention, an example of the promotion that we are still doing is, as I mentioned before, the Kinderuni, so the university for children offered by the University of Vienna during summertime, where we presented a video on hate speech, and we tried to address this topic to two different groups, from 7 to 9 and 10 to 12 years old. This workshop had a duration of 20 minutes or 50 minutes, and what we tried to do was also to encourage children not only to see the videos but discuss the topic. We were very surprised, I have to say, that the children got already a lot of knowledge on how to deal with the topic, what to do in the case that they are victims of hate speech. And I just, as the last point that I wanted to do is to bring the example of one of the draft of the card game that we are developing, and actually that students are developing. Pardon for that, excuse me for that. Where we have this in the form of a quartet, as the rule game, with some and with the connection specifically to the videos by linking to the QR code in the card. I think with this last slide, I want to thank you for your attention. I hope that you found the project interesting and hopefully effective for the objective that we aim to. If you have questions, I'm happy to receive one now after the presentation, or in writing. Yeah, you can contact me in these two emails, one email and LinkedIn as well. Thank you.
Thank you. If there are no questions so far, we will move on with our next speaker. Our next speaker is Dr. Karl Gladt. He is heavily involved in dispute resolution and consumer advice. He worked as a lawyer and is now the head of the legal department of the Austrian Institute for Applied Telecommunications. This is the ÖIAT, Österreichisches Institut für angewandte Telekommunikation. This institution promotes the safe, competent and responsible use of digital media with several projects. Dr. Gladt himself is the lead of the project Internet Ombudsstelle and provides ongoing legal support to many other projects, such as Safer Internet, digitale Senioren, or Watchlist Internet. He will now give us an insight into some of these projects. Dr. Gladt, the floor is yours.
Good morning. I hope everyone can hear me and can see my presentation. Yeah, I'm happy to be invited to this conference, and I'm happy to present some of the projects of our non-profit organization ÖIAT. The acronym ÖIAT stands for the quite old-fashioned name Österreichisches Institut für angewandte Telekommunikation, which translates to Austrian Institute for Applied Telecommunications, which gives a hint to the date of the creation of this organization, which was back in 1997. So at a time where the internet was still very slow and the use of digital media was not as widespread as it is today. Our general mission is to promote the safe, responsible, and competent use of digital media. And this is like the common ground of all of our projects. Some of them you can see here on this slide. I'll present 4 of those projects. Foremost, the project Safer Internet and Digitale Senioren, which focuses on the vulnerable groups of children and elderly people, but I'll also present my own project, Internet Ombudsstelle, and the Watchlist Internet, which focuses on the vulnerable group of consumers, if you may. So first I'll present Project Safer Internet. In a nutshell, the motto of Safer Internet is to create a better internet for kids. As we could see in the video in the first presentation, kids are confronted with various safer internet issues, as we call them. So these are very diverse issues. They range from harmful content, cybermobbing, cyber grooming, to gaming, the issue of screen time and online addiction, privacy issues, fake news, and hate speech. So there are various issues that we try to deal with to create this better internet for kids. A group of researchers have tried to classify those online risks that children might be confronted with in this quite interesting table, and they distinguish between 4 C's, as they put it. So they distinguish, you can see it in this vertical lines, the risk: content, contact, conduct, and contract. So the first vertical line, content, which mean the child is confronted with harmful content on the internet. So that might, of course, be disturbing content. It might be hateful content or pornography, of course. So in the horizontal lines, you see like the difference in the content that the child might be confronted with. The second line, contact, means the child is confronted with a harmful adult. So this covers issues such as cyber grooming, but also very sad issues such as child sex abuse, or also issues when children follow a guru online and to their own disadvantage. The third line, conduct, would cover situations where children are confronted with a harmful peer. So a person of roughly the same age. A typical issue of this kind would be cyberbullying, but problems we're also confronted with would be sexting, which ends up to be non-voluntary, or the communities of users which intrigue themselves to self-harm or other peer pressures. And lastly, another C was added, which would cover issues where a child is confronted with some harmful business, if you may. So this would cover issues like the abuse of identity details, or also problems related to online gaming or algorithms on social media. Of course, this is only an attempt to categorize these very diverse problems. So of course, you would also have cross-cutting issues such as privacy violations, which you can see in the last horizontal line. But nevertheless, I find this table quite interesting, and it gives some kind of orientation as how to categorize an online risk. Our project has been started in 2005. and it is based on a European Commission program which provides for the establishment of safer internet centers in each EU member state. Each safer internet center in each member state is based on 3 pillars. It's awareness, so raising awareness of issues. It provides help that a helpline shall be established, and a hotline where you can report illegal content. So we are the lead of this project, and we implement this project together with partners such as ISPA, the Internet Service Provider Association, or Rat of Draht, the helpline for children and young people. We organize roughly 2,500 workshops per year in educational institutions. Those of you with children might have had the chance or might have encountered those workshops in schools. And we also create and distribute information and educational material, which is then used in classes and can be ordered through our website. So this here, you can just see a screenshot of our website. So we offer this event service where you can book workshops for schools or parents' evenings and so on. The brochure service where you can order brochures for free, but you can also find online tools such as video tutorials, or we also offer a video a guide for to set your privacy settings on social media in a privacy-friendly way. So this would round up the presentation of our project Safe for Internet. So I will move on to the second project that I would like to present. It's the Servicestelle digitale Seniorinnen. So it's a service contact point for addressing the vulnerable group of elderly people. The main mission of this project is to enhance the digital literacy of seniors, since we see that seniors are more vulnerable due to a certain lack of digital literacy. I have talked with my colleague who is the lead of this project, and we tried to put together a few points which we would consider some of those or exemplary vulnerabilities. And one thing that always comes up is the issue, for example, of e-banking and e-government. In times where bank offices close in every small village and even in minor towns, people are more dependent on online banking, and we see a high skepticism on the side of elderly people to use online banking. We sometimes joke about that. Actually, while young people should be more afraid of the internet because they might disclose too much private information about themselves, with seniors it's the other way around. So they are too afraid of the internet. So they are hesitant to use things such as e-banking because they are afraid they could do something wrong. And I mean, it leads back. So, and we also saw in the context of e-government, for example, in situations such as the lockdowns, where you would need your digital signature, or you would need your green pass, that seniors had problems like getting these tools, and which were very important at that time. The first thing on e-banking leads to the second point, that another vulnerability, of course, is that elderly people are more susceptible to online scam usually. We see this especially on the examples of text scam, so where people are called by alleged Microsoft support teams and then grant access to their computers and grant access to any sensitive information on their computer. Another example would be love scam, where people are tricked into some virtual fake relationship and are intrigued to send money to fraudsters. Another example of those vulnerabilities would be in e-commerce that elderly people have, due to the lack of digital literacy, like worse access to lower prices because they would not compare prices, or they would rather not consult online reviews. So they do have some disadvantages here. The same goes for mobility, where you could also you have also worse access to certain offers if you do not use digital media. And the last point that we came up with was also like knowledge, like the access to information and the media literacy. So elderly people are used to classical media, and they find more difficulties in interpreting information in social media in a correct way, because they are more used to edited classic media. Other issues that we try to cover in the framework of this project would be the issue of ambient assisted living, which can provide a lot of benefits for elderly people, but also it brings up some issues, such as the issue of surveillance or private autonomy. Another very interesting topic is the topic of virtual reality, which enables elderly people to undertake journeys into the past, or can also be used to slow the progress of dementia, for example. So, as I mentioned, the general mission of this project is to enhance the digital literacy of seniors. It started in 2017 and basically follows the logic of trained trainers. So we support trainers and educational institutions in setting up training for seniors. We create training material, but we also do evaluate trainers and courses to make sure that the digital training has a certain quality. I'll go on to my own project, Internet Ombudsstelle. Internet Ombudsstelle has been created in 1999, or even 1998 to be correct. It is a consumer protection organization. We offer a free of charge alternative dispute resolution in e-commerce, but also in other disputes. We are one of 8 Austrian official ADR entities. And we also give legal advice on like any digital matter. So it might be classic e-commerce problems, but it might also be problems such as hate speech, data protection issues, or intellectual property issues. We try to offer as much information on our website so that, as we see that especially young people are less likely to seek advice in the traditional way, and are more used to helping themselves by seeking the information via online research and getting help themselves. So we try to offer this information on our website. just some facts and figures. We processed more than 2,000 cases last year, and in the ADR proceedings with Austrian traders, we do have actually a very high success rate, so we can resolve those problems in nearly 3/4 of the cases. And the last project I would like to present is a spin-off project of Internet Ombudsstelle. It's the Watchlist Internet. The idea behind Watchlist Internet was that at Internet Ombudsstelle we received a lot of complaints, of course, regarding fraud and online scam. So in situations where the damage was already done when people came to seek our advice. So we thought, okay, the better way would be to prevent damage before the damage is done by raising awareness about fraud schemes. And so we do this through our website, where we offer up-to-date news about online fraud and fakes. And the idea behind this, that a person which is about to order something online and then becomes suspicious of some fake shop shall Google this domain of this online shop and then come upon the Watchlist Internet information as the first search result, so that eventually the consumer does not order, does not submit this order and doesn't transfer any money to fraudsters, but gains this information before the damage is done. Here you can see a screenshot of our website. It's being redone. It's going to look different in 1 or 2 months. And actually, it's a very successful project. We do have a lot of website visits every month. And you can see for yourself, it ranks very high among search results regarding online scam. One thing is that we tried to develop, or this is our newest project, is the fake shop detector. Since we are always dependent on reports about fake shops, we thought it would be better to find and identify fake shops before they are reported to us. So together with experts from the Austrian Institute of Technology and developers from XNet, we developed a browser plugin which shall show you in a traffic light system whether a website is safe. And it does this by machine learning. So it analyzes the code behind the website and looks for typical criteria of a fake shop in order to issue this warning. So we would be happy if you try out, if you download this browser plugin and try out for yourself. And actually, that finishes up my presentation. Thank you very much for your attention, and I'm happy to answer any questions.
If there are no questions, we will have now a short break for about 15 minutes. We will continue at 10. After the break, we will hear about the proposed EU regulation on surveillance issues and child abuse, the proposed EU regulation against child abuse. See you in 15 minutes.
Sorry to interrupt, but there is a question coming. And I think Annemarie is hosting the questions, right? So Annemarie, please.
Yes, exactly. Thank you very much. We skipped the question part a bit too quickly. So we have a question in the chat where the question is, since education is an important factor in the protection of rights, how could a mandatory or mandatory education of especially seniors look like to prevent further harm to this group? I don't know.
So I assume this question goes to Dr. Gladt.
Excuse me, I stepped away from my desk
yes,
for a moment.
I'm
sorry.
No worries. I will just reread the question. So the question was, since education is an important factor in the protection of rights, how could a mandatory education of especially seniors look like if we want to prevent further harm to this group? So it's a question of education.
Mm-hmm. A mandatory education for seniors, yeah, it's an interesting idea. I mean, I think it would be, I don't know. I mean, it would come up to some sort of digital driving license, I would say. I mean, but I think it would be too much of a restriction of fundamental rights to introduce such measure. So I think this is no viable way to make education mandatory. So you would have to make this education offers more attractive to elderly people and yeah, make clear to elderly people that they miss out on many things if they don't use digital media.
There should be better offers and maybe just offering more education.
Yeah, I think so. It's like there should be more attractive offers to elderly people. So it would be like it would be educational offers which are very long going, meaning that it's not enough to have a workshop for once. So it would have to be constant recurring training, and the one important thing that it has to be close to elderly people. So an idea would be to introduce digital offices in senior homes, for example, or people who like try to educate elderly people in digital matters in a like sustainable long term way. But mandatory, I think, is way too restrictive.
Yeah, absolutely. Okay, perfect. I think we do not have any more questions, so then we can go into the break now. And I say thank you.
So welcome back to the IDLaw 2022. In the meanwhile, we've collected more questions, got more questions on YouTube. We will address them later on. They will not get lost and will receive your answers. Thus far, we've heard about many projects on the protection of vulnerable groups. Now we will hear about proposed legal measures to be taken in order to ensure the protection of such vulnerable groups. Our next speaker is Magister Erich Moechel.
Hello.
An award-winning journalist at FM4 with a focus on net policy issues. He has many years of professional experience on the topics of surveillance and data protection with a focus on the EU. He will now present the proposed EU regulation on the prevention and combating of child sexual abuse and share his analysis of this legal instrument. Magister Moechel, the floor is yours.
Thank you. I'm just trying to share my screen. I'm just trying to share my screen.
You can share a screen when you present on the fourth button. You click present. And then you
here.
Share the slides.
Well, it's not exactly slides. No, I don't have slides. I just want to share what you can see on my screen, but it doesn't work. Anyway, it's all online, and I will present you all the necessary links afterwards. It doesn't work here. I just stopped the screen. I'll send you the links. So we are here to talk about the protection of vulnerable group. I have an example of how not to do it. As you all should know, there is this CSAR proposal, which is de facto a mandatory data mining proposal for the net, and this is presented as a measure to protect the most vulnerable of all, children that are online. This is simply what's going on. It's simply a false flag operation, and I can prove it. I've been following the process, the making of, back to 2014, and I've documented in about, I'd say, around 60 long read articles, every move they made. So where do we start? I'll try to share my screen again. Share screen. Yes. No, it does not work. I don't know why, but anyway, let's start. Last week, as you know, there was a binding resolution in the Austrian Parliament against this proposal, because people slowly understood what's at stake here and what is going on. So we need to jump back to 2014 to get an idea how this came into a law proposal around mid 2022. So in 2013 there were the Snowden revelations. The reaction of the public was encrypt your traffic. In 2013, 85% of the web traffic was public. So every national state security agency could grab it off the routers at the core internet exchanges, and this was their main business. In 2015, already 65% of web traffic had encryption. So the spooks, as we call them, lost really one of the most valuable assets to be able to track everything down on the net. Then came the first proposal. It started in 2014. There was a proposal, golden keys for security services and the police. So they would have another point of access to data. And this was going on until 2016, and it was not the campaign was not running well in 2016. Terrorists, there was this terrorist problem in 2015, 2016, ISIS, and so there was the proposal, mandatory filtering of all contents because of the terrorists. This didn't work out. The anti-terrorists, it was a regulation, did not contain mandatory filters, which would have been entirely stupid because the terrorist contents are so sparse and few compared to the rest of the internet, you wouldn't have found anything. So what to do? Next was a copyright proposal in that got through Parliament in 2017, and this already had somewhat mandatory filtering. This is what they were after. A new interface they could dock on and suck off data, because meanwhile, 99% of the traffic had secure transport encryption. So all this snooping on the routers didn't produce many results anymore, because you get encrypted traffic and so what. So then came this proposal, and it took a long while from the beginning. And in the meantime, the EU was full of data mining craze. Artificial intelligence everywhere, data mining everywhere, and in every field they tried it, even in the most risky fields. And then came Commissioner Johansson, and all these law enforcement and national security guys assembled behind her that had run the first anti-crypto campaigns in the early years. So it's basically the same thing they wanted then. They just abused, I must say abused. They abused endangered children to propose something entirely different, which wouldn't help the children at all, because you can't do it like this. Order top-down processing of large parts of social networks, and then let's see what comes out. And that's basically this proposal now. And if you see what is contained in this proposal, it's a horror. They want to set up a new agency based on the premises of Europol, who have already much experience in data mining, because of the children. And this EU Center Against Child Abuse would be able to practice methods the EU members of parliament refused to hand over to Europol. So it will be another agency, but under the same roof, using more or less the same technologies, but with a license to use methods Europol was not handed over in the Europol regulation that went through Parliament in June this year. So you have this proposal here, And there is constant lying going on, especially from Commissioner Johansson, using marketing numbers from Microsoft marketing and declaring, well, this method will produce about 90, 80 or 90% hits. The opposite is true. Everybody knows that artificial intelligence constructions, data, you may call it data mining, you may call it big data, it's always the same components in. It's always big data, it's always data mining, and data mining is practiced by using artificial intelligence, making its mind what this could mean. It's called, forgot, machine learning. It's the same thing. It's all part of one big setup. And this is what they were after from the beginning in 2014. So Mrs. Johansson is telling us numbers that are manipulated and wrong. I can give you an example. The depictions of child abuse rose 4,000%, have risen 4,000% from 2016. I can tell you, these mandatory filters that are already in use everywhere in the social networks, these mandatory filters, wait a minute, I've got a bit of a cold and it's hard to concentrate. So yes, there have been a software program, a software set up by Microsoft around from 2009. This is called, it compares the hashes of random photos on the net or delivered by law enforcement officers. It compares these to a database where all those known samples are being collected as hashes. So they don't look at it, they look at the hashes. And this will work not so badly, but it could only do images. And now you see you have seen the explosion of videos on the net. But this software that is being used by virtually all social networks could only analyze stills, pictures, and not videos. In 2016, this software, Microsoft was not alone anymore in this field, delivering this software could understand videos as well. And that is where the rise set in. And that is why this crazy rise in numbers set in. They simply could not analyze videos before. So this is really bad political style. And there is another factor that's much underestimated, but you see that the numbers in Germany, around 40 to 45% of all the perpetrators of so-called child pornography are children themselves and young and very young adults. Sexting has become a thing even by people as young as 15, 14. Some are only 13, and that makes a difference. So nearly half of the people who would be indicted afterwards would be very young people, not comparable to all these perpetrators and bad uncles around, and they are, of course. And that's how the law giving process worked in this case. So it's all based on wrong numbers, on wrong assumptions, and those people in Brussels at the commissions being so-called technocrats. Technocrats are people who are always watching new developments on the technology market without having the slightest idea of the technology itself, and trying to employ this technology for setups and for purposes the technology was not made for. So especially with an uncertain base of basic big data that are being analyzed. So if the data sets are very inconsistent and random and you don't know where they are, everybody in technology knows that this produces incredible rates of false positives, of false hit. In this case, these people, this will lead to perfectly normal people to get indicted because the algorithms found some correlations. And just imagine being a family, being on WhatsApp. You have grown-up children, there are grandchildren, there is this holidays on the sea, there are children running around on the beach. Well, that's where the technology will snap in. An adult and a child on a picture, let's look closer at this. And this is the danger of this proposal. Immense rates of false positives, and the poor people at the EU center will have to check through all this. This will not work. This will simply not work. Everybody in technology knows it. The politicians just don't listen, and they have a reason why they don't want to listen. In 2014, data retention was killed by the EU Court of Justice, and the Commission told the member states they will come up with another data retention proposal, and they will do it like this or try it like that. They did, and they miserably failed, as you see at the 6th or 7th consecutive verdict of the EU Court of Justice. Data retention is illegal. For big data analysis, you need additionally data retention, because you need to collect a large mass of data to be able only to start the process. So you have data retention, mass surveillance as the base of the entire proposal of Mrs. Johansson. And I don't know what this is. Is this just a high level, such a high level of ignorance I'd never seen before? Because this is really top. I've never seen such ignorance before. Or is it something else, a deliberate move to fulfill what the Commission had told the Council in 2016, I think, that the police would get new instruments for policing. Now they're trying to do it like this, and it's always the same. But the children. Makes no sense to propose to introduce a regulation that will not work for children, will simply not work. That's it. But there were these promises back, and the Council always demanding what's up with our new instruments for our law enforcement, crime is rising, and so, you know, the usual things I've been hearing for the past 28 years. Every single surveillance proposal from 1995 started with the same catchphrases, so to say. It was either child pornography or terrorism. Even the first GSM police laws for the police, so police could access GSM calls and GSM records, was done under the flag of abused children or terrorists everywhere in Europe. I mean, aren't they getting fed up with proposing always the same and using always the same propaganda efforts to push it through? There are other ways to protect kids. Against grooming, well, a mandatory year early in school, so children would understand what's out, what can be out there on the web. They don't do this. They want to introduce top-down methods for their own purposes, which have nothing to do with child protection. The proposal of Mrs. Johansson came from a high-ranking officer in the British National Security Service, GCHQ, and he did it publicly. This is all public, and I'll give you the links thereafter. It's only 4 articles, but everything is contained in them. There are long link lists and timelines in, so you can follow every single step to up to today. The latest of these articles is from the end of October, and the earliest is from mid-2014. So I've followed this for quite a while, and I'll be happy to answer your questions afterwards or discuss this in any form. Thanks for your patience. I think I was too long, but that's basically what I have to say.
Thank you, Mr. Moechel, for your presentation. I heard that we have already questions. Anne-Marie, please.
Yes, perfect. Thank you very much for your interesting talk. So one question that came up during your presentation is whether the proposed CSAR is not unlawful. So if already the European Court of Justice has ruled in September that traffic and location data of EU citizens may not be stored except in cases of a serious threat to national security. And the person asking the question is referring to the mass data retention of Germany's Telecommunications Act. And also, if I'm informed correctly, Mr. Heidrich would be so kind to join us on stage already, because maybe we can have a cross discussion regarding these legal specifics.
Yeah, I think I can answer that. Hello, thanks for inviting me. I'm a little sad that I have to sit here in my office in Hanover and would really prefer to come and see you in Vienna. Thank you for the interesting talk. To answer that question from my perspective, yeah, it might be. There is a pretty high chance reasonability that this is not legal. There's been an analysis from the German Constitution blog, which is quite well known, and they came to the idea that this is probably not covered by the European and the German Constitution. But that doesn't stop the European Commission from proposing strange things as they did again. Yeah.
Yeah, right. I can only agree with you, Mr. Heidrich. I'm pretty familiar with your workings in the law field for, I think you're for Heise. Yeah. Okay, I'm not mistaken. Yes, that doesn't stop the commission from doing this. They just claim that this is wrong, and because of this and that, and then they're off stage again, and nobody can say a word to this. So they just try to sweep all this under the carpet. I don't know whether you have seen the planned conference on 16th of November. You have them all there. You have them all there assembled, and the worst thing is the most prominent person there is Jared Kushner, Trump's son-in-law, and for the InHope organization. And the rest are interested politicians and what we call snake oil peddlers, companies that try to sell expensive solutions, one-stop shop, just get this software and you are done and the problem is gone. This is the way technocrats love this, because they say, look, there's a solution here, and they always try to find technical solutions to social problems, and this is the main problem, I think, of these times. They never changed. And there were people in charge at the EU Commission who had no idea what they were talking about. Mr. Oettinger was at that time Commissioner for Digital. This person did not even know how Wikipedia works. He had never had an email address of his own. And such a person ran the job of Commissioner for Digital Services. He learned about something about TCP/IP from telecoms who are not native to the net. And as long as you have such people up there deciding in decisive positions, this won't change. It didn't change a bit in the 28 years I followed this stuff. I've been following this, well, stuff that is sometimes very hard to digest, I can tell you. So that's my statement, please. Somebody else.
If that is okay with you, I'd like to take a step back and tell a little bit about those things we're discussing about, because maybe not everybody's so familiar with this proposal. It's another EU Commission proposal. Like most bad things come from the EU Commission, especially when it comes to people's rights. And what they are trying to do is basically to build up a surveillance of every kind of electronic communication. We're talking about communication services that includes telephone, email, messages, chat, regular chat, but also chat like in parts of games or in dating apps and everything, or video conferences. And all these communication, like in texts and images, in video and in speech, should be monitored by some policing agencies or by some agencies which are pretty close to the police. And there is also a plan to break up encryption. End-to-end encryption messengers will have to be opened. So there is a possibility to see what's in them. There is also a new plan which includes hosting services, which should be scanned regarding web hosting, social media, video streaming, file hosting, and cloud service. So basically, it's like the whole internet will be scanned in the future if this proposition comes into life. What is the reason? The reason is basically a good one, the protection of children regarding CSAM. I hope I pronounced that right. I always call it CSAM, which we used to call child pornography, but that was really a bad name because there is no pornography when it comes to children. So we should like call it CSAM. And there will be automatically, as Mr. Moechel said, there will be automatically scanning of like the images. There will be an automatic scanning of videos and also text, which is really horrifying to my mind. I think it might, I'm not calling it good, but it might work. It might work with photos, but I'm sure it doesn't work with text. There will be artificial intelligence looking into text, and if anything goes in the direction of CSAM, it will be reported. There will also be a monitoring for grooming. So also in text. So if like grown-ups will approach children with sinister motives, that there also should be used artificial intelligence. That will definitely not work very well. And I really see, like, I have a law firm. We talk to a lot of our clients when there is like the idea that somebody might, some of the employees might store CSAM or watch CSAM. And then I also see our law firm being involved in like some criminal investigations because we talked about CSAM. So this, I strongly agree with Mr. Moechel. Everything about this idea is terrible, and there are way better ideas of protecting children. And I'm really angry about these ideas. This is, as Mr. Moechel said again, this will be like the first step. CSAM is like the best way to put certain ideas into work, like scanning everybody, and the next thing will probably copyright. They probably scan that for copyright, and the next thing, and then maybe terrorism. This is like the way it goes. That's the way, like starting with CSAM, then copyright, then terrorism, then whatever. So we should all be aware of what's coming there, and should do what we think is best to speak out against this. Sorry, I just want to put that into perspective. Thanks for having me.
So who is next?
Yeah.
Shall I do the show?
Yeah, I think this is a great moment to open the panel discussion. Sorry, with our head of the department, Professor Dr. Nicholas Forger. Nicholas, you're muted.
No, it's a feature, not a bug. Thank you. Yeah. So good morning, everyone. I'm very pleased that I have the privilege now to chair the panel debate. Before doing so, I may very briefly introduce the panel to you. So apart from the people you know already, in particular in the order on my screen, Erich, who gave the first introduction, and Karl, who gave the second introduction, sorry, and Karl, who gave The first one, if we don't count Mariana being part of the team here. So apart from Erich and Karl and Joerg, whom you already know, but I still need to introduce him. Joerg Heidrich is a lawyer. He has been working for one of the most important publishing houses in Germany when it comes to IT and information technology. Heise is a publisher based in Hanover in Germany, which was a very positive coincidence for my life. When I spent quite some years there, I therefore had the privilege to live closely and to work very closely to him, which is also the reason why we know each other quite well. Professionally, he is one of the leading voices when it comes to to IT law, understanding IT, which is not very common, unfortunately. There are quite some IT lawyers, as you know, who have only very rough ideas. And Erich was just mentioning one of them, although I'm not sure whether Oettinger is a lawyer by training, but I would assume that it could be. I don't know. So Joerg is definitely very different for not only because he's not working for the commission, but also because he really has a clue about what he's talking and what he's writing about, and has been doing this now for more than 20 years now for Heise. And just to add a little bit more on this, he's also, of course, dealing with the day-to-day legal business in the publishing house there, and also with the data protection issues in the publishing house being I don't know whether you still are, Joerg, but you were the data protection officer of Heise, and I assume that you still are, which is also quite some fun, I think. So this is Joerg. Then we have Veronika Nagy with us, which is a Hungarian name, I assume. She's an assistant professor in criminology at the law department of Utrecht University and international research fellow at the University of Milan in Italy, so working in the Netherlands and in Italy simultaneously, with a specific research interest on the topics we are covering here, in particular surveillance, digital inequality, with a focus on the connection between mobility and technology. She will also bring quite certainly the legal background here more into light. Then we have Sebastian Öhner with us. Sebastian is the third lawyer, so I'm very sorry that we are so many here. Sebastian is the third lawyer. He is based in Vienna. He works as a legal counselor for one of the major NGOs dealing with children's rights in this country, Wiener Kinder- und Jugendanwaltschaft. So that's it's not really an NGO, I'm sorry. It's a hard legal institution dealing care with children's rights in day-to-day practice. But on top of this, he's working in an NGO. He is working in the Austrian League for Human Rights. So somebody who is doing children's rights very fundamentally and also on a day-to-day business with a specific focus, as I said, on children and adolescents. And last not least, we have Annemarie. Annemarie Hofer is part of the team at the department. She is not going to give a presentation, but she is the one helping us out with the issue that we had with the questions at the very beginning, because we were too fast in closing the debate after Karl's presentation. So there were quite some questions still coming then. So what I would suggest, therefore, would be that Annemarie gets the floor first, summarizing questions that still go to Karl's presentation. Karl could then open the panel debate in answering those questions. And then it would be Joerg, if he still has something to add, Veronika and Sebastian in this order. And then during this, and in particular after this, we are very, very open to any questions that you might have on the panel or off the panel. Kindly use the chat function on YouTube. Annemarie and Peter are taking care of the questions there. Annemarie, please go ahead.
Perfect. Thank you very much. So our main issue seems to be that we have a bit of a delay on YouTube. So that means that we get questions after we have been talking. So what I have been doing now is that I have just summarized the questions that we got on the previous talks. And we found two main issues that people were thinking about. So the first one is concerned about technical questions and the question how we can determine and especially verify vulnerable role characteristics. For example, how can you verify how old someone is? And how can you identify people using specific services and thereby protect them? And then the second question would be which role privacy enhancing technologies could play for the protection of other data subjects. So that would be more of the technical subject. And then the questions revolved a lot about responsibilities and who should be in task of managing and protecting the different groups. And so we also had that in the very beginning with the question with mandatory education and voluntary education, where we could say children have some kind of mandatory education in school, but for other people you cannot just give them mandatory education. And this leads to the question of who should be responsible, for example, scam prevention, and if it should be rather the individual user or if it shouldn't actually be the responsibility of banks, for example, or the service providers or internet service providers. And if this should be something more regulated by states, which again, of course, leads to the question how and who could regulate international aspects of this. And those are the main topics that came up in the chat. And so maybe we could start with that.
Sure. So maybe regarding the first questions, I commented on the very first question. I don't know whether I was still, like people were still listening. So this was this question on mandatory education for elderly people, which I would find way too restrictive. So the idea would rather to make those educational offers more attractive and to motivate elderly people to use those educational offers. As to the question regarding age verification, well, of course, this is a sensitive topic since it could also lead to a permanent surveillance of users on the internet. I think as soon as like the system of EIDs is in place, maybe there could be data protection friendly ways to verify the age of users without that the user has to disclose more information than this. Of course, then you also would have the issue of jurisdiction. So of course you could obligate providers to implement such age verification, but as soon as a provider decides to move its seat somewhere else, then it would not be a subject to the jurisdiction anymore. So this is, I think, something that we can see in Germany, where there are quite strict age verification obligations, as I understand, and where providers just move elsewhere. As to the question, let me just, or maybe as to the as to these technical issues, maybe someone would like to comment on this.
Yeah, please go ahead, please.
I cannot answer to the technical details, but I can answer to that there are also very exciting plans in that area when it comes to the EU chat control stuff. There will be, or there should be, a mandatory age verification for communication and storage apps, and age verification for app stores, and exclusion of minors for installing many apps. And that also means if there will be a mandatory age verification, that there is a mandatory verification for everyone. So that will basically be the end of anonymity, at least in that part of the web.
Mm-hmm. Erich, you wanted to contribute to the technical part, yeah?
Yes, age verification. There are two ways to verify the age. One is the plain thing, as is being done right now. You just hand over a copy of some ID card, and that's it. With this method, you you would hand over the most precious data. These commercial networks are after your age, your name, so they can add this, and it's verified, so they can add this to the profile they are keeping of you and your activity. They would have real name and everything. The other thing, as Joerg said, with the EIDs that are getting up, there is a trap in there. The providers, if they still get the data, the Google and whoever you can imagine will say, okay, we need this age verification. It's now mandatory, and there will be there must be a process how to check it. And so it's always the state coming in saying, oh yes, this is this person is not underage, and it's this person is entitled to do this or to participate somewhere. Well, so some state database will display a perfect profile of my interests on the net of all the sites that demand age verification. This hasn't been discussed yet. This hasn't been discussed by anybody. We deliver another profile this way to some bureaucrats in our own country, and they can collect this and immediately gain knowledge about things they would never have learned otherwise. This is a real danger. No matter how you put it, either these or this site will get additional data to be added to an existing profile. And this is really a danger if you look at Hungary or other countries like Poland. This is a true danger for the people themselves. So I would really want to hasten up this process and say, oh yes, we must protect the children. But at which cost for everybody else? Yeah, that's it.
Yeah, absolutely. There's another question on children's rights coming from Joerg. So from the panel, please go ahead, Joerg.
Yeah, thank you. I have a question on your opinions regarding children and social media, especially when it comes to influencers. I see a lot of very extremely negative influences coming from influencers, especially on TikTok. I'm really astounded and worried that there is basically no regulation regarding TikTok, at least in Germany. I don't know, maybe it's different in Austria. No data protection regulation, no regulation whatsoever. And also we lack regulation of influencer marketing stuff. Okay, you have to put somewhere that this is marketing, but that's all. Right now there is, maybe you've heard of it, there's a terrible show going on with the influencer Casey Hummels. I don't know what she's famous from, but that's probably not important. Who like took 10 other influencers to some Greek isle and to do something against depression. Basically, what they do is, ooh, go outside. The sun is shining. That's good against depression. But don't forget to wear these special sunglasses, which are proposed by my sponsor, and click right here to buy them. And I think that is, from so many perspectives, absolutely disgusting, but also dangerous. And I would like to know on your opinions of if this should be regulated, must be regulated, or leave it to the market, whatever.
Yeah, before I hand over to Karl, let me just emphasize again, Jörg, I think this is a beautiful example why it's so extremely important that lawyers and lawmakers have a clue about what's going on outside. And TikTok is something nobody is really interested in, right? Because it's people like you and me in our age group, which means that we are not on that platform and we simply don't know. It's unbelievable what's happening there on a daily basis, and nobody dealing with the legal implications is really into it. And Karl, I'm very happy to hear now whether you are the one taking care of this, or if you know at least people who are.
Well, we also have become aware of those very problematic influences. So one issue that we came upon recently were influences that build up groups with eating disorders, and they would then build up this group and give out challenges and actually worsen those eating disorders upon those members of those groups. So they would encourage like to even lose more weight and let me see your pictures next week and you can do this and so on. So this is of course very dangerous and very has to be regulated in some form. So this is not something that you could leave up to the market whatsoever. So this is something where a public authority must interfere. The challenge of course is to like how to draw a line between like simply marketing practices or when they cross the line to encouraging detrimental behavior on behalf of the person they influence. I don't have any immediate solution or answer to this, but maybe Sebastian Öhner can chip in.
Thank you very much. Is it okay if I start?
Go ahead, yeah. Go ahead.
And first, because it's the first time that I speak, I want to thank you for the invitation and the nice introduction as well. And also say that, like, I'm not an IT lawyer. In a way, I'm a children's rights lawyer, so that's my perspective, and that's what I can bring to this discussion maybe. And also, right, starting from this point, what I wanted to add is that it's important to really also focus on letting children and young people participate when we talk about this, also about these regulatory perspectives, what we need from the law in these fields. Because Professor Forgo mentioned before that sometimes we don't know about the problems that really occur, and we are not on the platforms that really are in the focus of our discussions. So then we have to bring in the people who are on these platforms and really have to hear their voices. And I think that's, from a children's rights perspective, very important, maybe one of the most important parts. We see that this also works on an international level. For example, the general comment from the Children's Rights Committee on Digital Children's Rights was created with children in a participative manner, so they can bring in their own voices and their own thoughts. And this can only be good for working on real solutions and finding out what really works for children and young people who are concerned with these topics in a way. Regarding the influencer problem, what we are dealing with also is with kidfluencers, like children who are influencers in a way. And we see that there are also no regulations regarding that. We even have the prohibition of child labor in Austria, but still there are kidfluencers who are really having a lot of views on their different platforms, earning a lot of money, having a lot of contracts in a way, but without nearly any children's rights regulations behind that, because our legal systems just do not work in a way, and that also the children labor law doesn't work in a way for these specific questions. So we see that we don't have this children's rights perspective in a way in different fields that we are discussing right now, and this leads to the problems that we have. And yeah, I will leave it for that now. Maybe someone else wants to add something to that.
There is a question from the audience, and Annemarie will kindly bring it in.
Yes, perfect. Thank you very much. It lines up perfectly, actually. First of all, the comment says, thanks for the nice panel. So to all of you, thank you very much. And the question is, how can we ensure that well-meant protection measures do not simultaneously limit the ability of vulnerable groups to participate in digital society? So meaning by overprotecting and thereby excluding people.
Is this going to Karl, I would assume, or is it Sebastian wishing to answer, or both of you?
I can start and then I can continue. What we're saying is that we have to find the right balance between the protection and the participation of children and young people. So the digital world is very important for children, so you can't just ban them and have too much protection for them, so they can't participate in a way. But it's also, you have to seek the fields where protection is necessary and then find out how far this protection has to go. But as I said before, always from a participative standpoint. That's for us really important. We see some aspects that already got mentioned before. For example, the educational aspect is really important for us. So if you educate children within their children's rights and also within the specific laws that are important in the digital world, they will move better within these participative and can also protect themselves in a way. So there's this participative way. And on the other hand, you have to really focus on what are the aspects that really need to be protected. For example, a big problem that we deal with is like in-game purchase, where children really got within like online games, they really get very often exploited and pay a lot of money within like the online games that are also very addictive and where there's a lot of social pressure. And we see in this perspective, for example, we need protection law, also education, but also law that protects children from getting into these contracts. So the balance is important.
Yeah, of course, it's a very meta question, I would say. Of course, I think you may limit like the legal capacity in some sort as you do in any other way. So in order to protect those vulnerable groups, you might have the legitimacy to limit their ability or their capacity to participate or to especially bind themselves in any agreement. So we do not only see this in regarding children, but we also got the question a couple of weeks ago where the daughter of a senior person who went crazy online shopping and spent a lot of money because she did not know anymore what she did, and the daughter asked what can she do about it? Can she restrict her mother's e-commerce shopping behavior because she has to cancel all those orders that her mother makes through the website? So you also have this in this regard. So I think as soon as a person endangers him or herself, you do have the legitimacy to restrict, to apply some sort of restriction at the end. And just another comment as to the influences. I mean, our task, or what we see also as our task, to make people aware of those issues on social media whatsoever. So in fact, we see as our task primarily to make people aware of what's going on social media, what are the problems, rather than like propose regulatory solutions to this.
I see. Thank you very much, Karl. Veronika, you have been waiting so long now, and there's so much you can bring into the debate. May I hand over to you, please? You have the stage and all the time you need.
Thank you, Nikolaus. Yeah, it's first of all, I'm also very pleased to be included into this discussion, and I have a lot to learn from you all. As an anthropologist working in the field of criminology, we have different ideas from all perspectives engaged with this topic. Of course, we are also kind of critical with the surveillance aspects and the invasive aspects of data collection of data subjects, and also the limitations of usership and the questions of accountability. Who is really accountable for which problems? Is the daughter really accountable for, or can we make a person who is overusing particular services online should be protected from herself, like a customer who is really enjoying online shopping without really taking care of the necessities of the financial aspects. But let me zoom in and out a little bit also based on what has been previously said, what I would like to maybe touch upon in this discussion. So first of all, the user's experience. I think we tend to think in a very protected, very kind way about any vulnerable populations. I've been working with minors, ethnic groups, refugees, people from different contexts in different gender positions who would, I think, construct the idea of vulnerability on quite different ways than what we can do through the law. And I think that's one of the issues what we need to take into consideration. What is the context? We are talking about vulnerabilities. And what kind of vulnerabilities do we define and associate with which groups? And I think that's a very complex thing. And with the idea of course, we need to kind of take care of with legislative regulations of the protection of users, if we consider them as consumers or just as subjects of penal offenses. I think it's really concerning that this kind of new associations that come up with protections of vulnerable groups come with the conformism and the idea of conformist usership, which leads to some extent some kind of cancel culture and also a kind of criminalization of or marginalization of user groups. So let me give you an example. I think if you look at how the social interrelations of the same devices and same accounts would work just in one household in different countries, then you see that there is a very diverse pattern about how we are engaging with each other's accounts and devices, which we do not necessarily should be identified with. So what is regularly happening is that we also call in many discussions the users who are social individuals data subjects. So the first thing is that it's important to differentiate the information which has been shared through particular infrastructures and devices about this person, and is this person really the person who has been associated with that data? Is it private data, personal data, or regular data? It doesn't really matter, but I think this kind of detachment would help to understand who is standing where in this kind of vulnerability discussion. The other thing is the more macro perspective I would like to engage with, which is not necessarily the obligatory engagement of authorities and in terms of protection, but also the correlation and the dependency relation between the market and authorities. So what we see that it's not just the knowledge which is oftentimes missing from the from the legislative parties in terms of not only the technological or infrastructural bits, but also the digital cultural understanding of how and why people engage with particular platforms. Why is it important to pay attention for influencers, in particular social networks? What are their role? Are people really approaching them with a critical, actually, question mark, and or do not even take them serious? And who are those who are practically really vulnerable for this kind of marketing strategies they also represent? And I think when we talk about the role of all these kind of big corporates shaping these markets and shaping these kind of interrelations, they are also public authorities are also dependent on these services and also of this kind of technologies many of these kind of corporates provide. So we cannot really detach anymore this kind of stakeholdership in terms of accountabilities between public, private, even civil societies oftentimes engage with surveillance of vulnerable groups. If you look at the UNHCR practices, for instance, regarding the refugee applicants. So I think there are two main things that we have to be cautious about. One is this kind of social, political, and economic context where this kind of usership is identified as vulnerable. The other thing is how we differentiate the type of media literacy we find essential when we talk about education and how people should be engaged with particular knowledge about the use of internet. And the third is to be very reflective in the law enforcement and policy making about not to engage with what we call the CCC, like the control, conform, and collect approach. So the more data we have, the more control we practice, the more conformity we should frame for userships in different digital contexts. So I think the threat is, when we talk about these discussions, is that we reproduce the old school profiling paradigm, which is coming from traditional policing science, so that we don't engage with the new digital transformations of societies from this strong policing approach, but much more from an anticipatory approach of how to engage with these kind of transitions from a more anticipatory legislative angle as well. I'm not sure if it's clear, but please let me know if you have questions about this. I think you're muted, Nicola.
Yes, I'm sorry. I'm too stupid for this gadget here. I'm sorry. So thank you very much, Veronika, for this. I very much appreciate this contribution. We do have a question from the audience, and Annemarie, perhaps you would like to bring it in.
Yes, perfect. Thank you very much. So the question goes actually to all of the panel. Boris is asking if there are specific thoughts on how we could tackle the highly addictive potential of social media platforms.
Mm-hmm. Perhaps again, Sebastian, this could go to you, and perhaps it would also be then a nice opportunity for you to take the stage, if that would be okay. May I put this on your shoulder?
Yeah, I can answer to that. Mm-hmm. Having said again that I'm not an IT law specialist in a way that I know specifically on how to tackle these addictive codes probably behind the social media platforms. What I can say is that this is a part of what we want to tackle if you take children's rights perspective. So we see that there is the addictive potential of social media platforms in various ways, and they really want to like especially young people to stay on their website, stay on their take their content to hold them close to them. And what we do and what we always try to do is, first of all, work with children and young people. That's one main aspect, I think, because there are some positive parts also about social media and the connection that young people can have with that and how they grew up with it. But there has to be more awareness and realizations of the dangers on how you have to work with them. I think the first video that you showed within the Privacy for Kids project is really part of that, what we try to enforce as well. with our work in making children understand how to deal with these topics. Also, and tackling different problems that are regarding with that. For example, the addictivity of these websites. We also work with their parents, for example. That's more a practical approach in a way, so that there are some websites or some possibilities on how to really work with their children on tracking how much time you can spend on the particular website, and really see how much time you spend on your phone. And that's also an educational way within families and within working with children on getting to know the problems that are behind that. And from a regulatory perspective, I would again say, I think there are people who are more fond of the ideas that you can really implement there on protecting or working against these addictive measurements within the websites. But what we say is that it is important to really work on that these addictive symptoms are becoming less in a way. Yeah, that's what I can say to that.
Thank you very much, Sebastian, for this. Actually, may I add to this a little bit more of substance about what's going on at the moment. So I think, and perhaps Joerg and Erich would be the right people to comment on this, because it's a little bit of tech and it's a little bit of Germany. What we've seen in the last, I would say, 2 weeks was a huge exodus from Twitter, leading to something which is leading back to the very early times of the internet. So I'm old enough to remember that. So to Mastodon, which is very different for many reasons. One of them is there is no platform. It's more a protocol than a platform. So everyone can do everything. It still looks a little bit strange, just like Twitter looked like 10 years ago, or I don't know, Yahoo 20 years ago, or whatever you want. But it's very interesting in my view. And the question that I would have would be, wouldn't that be an example where you see that legislation has a very heavy risk of simply missing the point, because either not expecting properly what's going to happen, like in this case, or being years too late? So shouldn't it be that we talk more with IT people and about technical protocols instead, talking about, laws and cases and legislation instead of that? Whoever feels comfortable with that question, please take it. Joerg, was this a yes, or was this handing it over to someone, right? So tell me to whom. I don't see.
I can answer it as well, but I think Erich is.
Erich, okay, Erich. Okay, Erich, would you like to comment on that? Actually, I found you on Mastodon, right? You are already there from very early, but you are muted, Erich. You are in the same problem like me.
Sorry, I just wanted to be polite, not to disturb you with my sneezing. So I've been to Mastodon from 2018 or so. I always changed between Twitter and Mastodon, but there was not much going on there. And the situation perfectly reminds me of the time in the 90s when the America Online users, which was a closed proprietary network, telecom style, but there were many people online there, and then AOL, America Online, would open up their network for internet access. They were separated from the internet, old school. So then we were in Usenet, these news groups, these discussion groups with sometimes very strict rules on not posting to more than 3 groups on one topic and things, and quite a lot of pedantry going on there as well. It was largely a technical community, largely. There were way more IT or tech people in there than anybody else. And when the AOL user came in with their habits, you can really compare this to Mastodon, because I observed the same thing now happening. There are people coming into a pretty tech community who had some reason to design it exactly as it is. And then those people came in from a proprietary network, and many of these started to complain about customer convenience issues they had enjoyed on AOL, and that would lack on the Usenet, and then the situations frequently became very unfriendly, very unfriendly, I tell you. The AOL people were called AOL losers. by the techies, and well, that faded away after a while, because everybody had forgot that they had been on America Online before, because now everybody was on the internet. So I don't think that this is such a problem. And Mastodon is quite different from Twitter. There are very interesting what the guys who built it left out. So you would see if somebody favorited your post, but only if you were online. If you see it immediately, and there is not this count how many retweets, or how many retweets, or how they call this, boosting is called. Somebody forwards your message to his own group, and so it's quite different, and the only real numbers you can see is the people answering you, because the answers would appear on screen, and you have to respond to these. There is no, all you have in numbers is a follower count. How many followers you have. That's more than good enough for me. I'm not interested in this stuff. How did this person react to my opinion, and have statistics on that? That's useless. That's useless except for marketers.
Yeah, Erich, but okay, Joerg is coming in, but just to be more precise in my question is, so we are celebrating now the Digital Services Act. We are celebrating the Digital Markets Act. We have 5 years of the Commission, or 15 years of the Commission telling us, listen, the new thing is platforms and we need to regulate them. And then suddenly something is happening that literally millions of people start leaving platforms. And Twitter is just one example. And this is, at least for me as a lawyer, a very interesting, if not to say fascinating phenomenon. And Joerg, I would like to hear your view, and then also Veronika ask for the floor. Joerg first, please.
Yeah, I'm not actually celebrating any of these acts, but I'm not sure if you really do.
Yeah, Oettinger would, if he were still in office.
He's also a lawyer. I looked it up. First of all, Twitter. People believe Twitter is not about legislation, but everybody knows that it's about some right-wing billionaire destroying everything, burning everything to the ground, which is really sad to watch, actually, but also pretty funny, I have to say. Fire them. Might not be really good. Please come back. So weird. It raises very interesting questions. We used to talk about that on a podcast we did last week with Digitale Courage, a German NGO, about decentralized versus centralized networks. And Mastodon is basically decentralized networks, and how if they do have advantages, I'm not sure about that. I actually have two very special user experiences when it comes to that. I've been simultaneously reactivating my Mastodon account just to look what happens, as well as to get acquainted to LinkedIn. Actually, Xing is obviously going to die. They're shutting down all these social areas, and they just want to be a job machine. So lots of people are also leaving that social network, going to LinkedIn, and the differences between feeling welcome at Mastodon versus feeling welcome at LinkedIn is a little bit different. Of course, I know the backgrounds of those services, but it is very obviously where you would feel welcome. But the question is, should there be legislation on tech and especially on networks? And I've also been around for a couple of years, and I can think of one good idea where the legislature is trying to regulate technical ideas, especially if the legislature is stepping ahead, like we're going to regulate that, and so everybody's going to use that. That always ended terribly. So please don't do that. Regulate if you have to, but don't try to go ahead as the legislature. That is terrible, and it never brought any good.
Okay. That was as fundamental as I would have expected it to be. Thank you. Veronika, please. And bear in mind,
first of all, let me echo the previous speaker, because I think there are. So my background is in linguistics, and I remember when we've been trained in the idea that the language should be also controlled, and there should be laws and regulations about what is correct and what is acceptable in terms of using language. But I think in the technological infrastructure, we have the very same kind of innovative, very organic nature of development and change. We can't just hold back or can't just discipline like we used to do with other kind of environmental or analog structures. So I think this is definitely one of the aspects we really have to understand, that this is not something there are obviously, so what can we do is to look at which stakeholders are we looking at, from which perspective, and what kind of behavior do we want to regulate in place of regulating the infrastructure itself, probably. The second point I would like to make, also referring to the huge migration or exodus from Twitter to Mastodon, which is very interesting because it has been actually happening before the whole transition or the financial transaction has been taken place among very specific groups of users on Twitter. And most of those who are engaged like us, I think, with technologies and try to understand the potential implications of ownership has triggered this kind of skepticity and the lack of trust of being present on particular platforms with our content. However, there are plenty of people who would consider this kind of ownership from a different perspective and would deny the fact of what kind of political identities are behind this ownership and what kind of potential technological adjustments would come with this kind of new ownership of the platform. So the question is to look at from a more broader perspective. To what extent does this kind of exodus illustrate those social interrelations we associate with this kind of digital presence, and how these kind of digital ecologies are actually shaping the interaction of different groups, which are probably not looking that much at the infrastructure and try to more take all the benefits and advantages of this, and not only from the extreme right of those who are associating themselves with particular political identities, but also from a very pragmatic point of view. If you look at people from non-tech discipline academic bubbles, how they still use and collaborate on Twitter. So I think there are this kind of social behavioral angles that are kind of marginalized in these discussions, which should, to some extent, should be pulled back in terms of power relations and also the kind of infectious usership, and probably also one of the core aspects, what has been also in terms of addiction already mentioned, is a seductive aspect of different kind of platforms and technologies. So what kind of effective issues are playing a role in our engagement with particular networks and groups and platforms, and how does that actually shape these kind of vulnerabilities and deviances?
Yeah, Sebastian, please.
Yeah, may I add one also specific topic on that? It's in Austria, for example, we have the youth protection laws who also try to protect like children in the digital world, and we see that like these youth protection laws, where we have 9 different, only in Austria, 9 different youth protection laws for every region in Austria, and they are really, how to say, really far away from the reality from children and youth here. So they state what should be child protection in the normal world. It would work, but for the digital world, it just doesn't work. There's no effective measurements here. Also, like the execution, which is like by the state policy or the policy of the region, is also not working very well. So here we see as well that there's we have to think what the law can do with child protection in the digital world, and what like digital innovative people can do, as you said before.
Yeah, I would like to take this, Sebastian, and would like to share one comment with you on this, which is if I think people who do have digital skills are also in a way a marginalized group, so nobody really cares about them, but different from elderly people and children, they are able to find a way through, and they are able to circumvent absurd laws and absurd predictions coming from legislators. This is very different when it comes to children and when it comes to elderly people, because they lack the skills. And in my view, they and this is more a comment now, but it's also a question. In my view, they simply fall through, right? Because the legislator doesn't really meet their needs, as you, Sebastian, rightly mentioned it, and they don't have the skills to help themselves. So what to do then? Is it then up to the legislator or us, being the legal people, to find some instruments that we know from consumer protection, for example, so that we need ombudspersons or lobby groups or I don't know what to help those marginalized groups to make themselves better heard, or should we educate those legislators and tell them what is possible and what is not possible? Or what would you suggest? I think this is going to Sebastian and to Karl.
Thank you for the question. I think that's a very important aspect. I wanted to start with another, because Mrs. Nagy said the CCC rule. In the children's rights law, we have the PPP rule, the provision, participation, and protection rule. So these are the 3 aspects from a children's rights perspective that should be always in place. Provision means that you have to provide the laws that have the best interest of the child always in the center. Participation means that you have to like really let children and young people participate within like within every part of lawmaking. First, making the law, living the law, and also everything that is surrounded by it. We have in Austria, we have within our constitutional law the right to participate for every child in every aspect that is important for this child. So that means from a regulatory perspective, that children and young people need to be part of lawmaking processes that really are important for their lives. So they can give their inputs on what needs to be protected and where they need to have, and how children and vulnerable groups can be also really be part of these legal systems. So that's something that I think is very important. And then also the educational aspect is something that really is necessary. I would say. So with children, we have the benefit that we have the school system where we can say, okay, it should be mandatory to have digital education, to have the education on how to act in the digital world. And I think this is a really important part of protecting children and also empowering them within the digital world. So these aspects should be mentioned. And sorry for the last thing I want to mention, that we have within our children's rights system, we have the best interest of the child, as I mentioned before, which always should be in the center of it. And the best interest of the child is a really interesting concept in a way, because it says that it's a dynamic concept, which is like always taken on the individual and specific situation of children, or a particular group of children, or a particular field, where you always have to question yourself, what is in the best interest of the child in every aspect where children and young people are within the picture. And I think from a regulatory perspective, we have to really decode this best interest of the child within the digital world for every law that we are making, and really set this as the standard. The best interest of the child is also within our constitutional law in Article 1 of the BVG Kinderrechte, which relates to children's rights in Austria, and is also really the most important part of the Children's Rights Convention. So that would be a very important aspect to always, if you make no new regulations, think of what is within the best interest of the child. And really let children participate within this process.
Thank you, Sebastian. There's a follow-up question from Joerg on this.
To Sebastian and Karl as well. I don't have kids, so I'm not really into the world of children's education. But I used to hear a lot of we should, we will, there should be like education on the digital divide, the digital development, whatever, on the dangers of social network. But is that a should, or is that something that does already happen? I've heard it like 20 billion times in Germany, and also social competence to see what is fake news and whatever, but nothing never ever happened, except maybe a few very, very good people which go to the schools and do workshops like Karl's NGO does. Is it actually happening in Austria? Because in Germany, it's definitely not.
Sebastian, would you like? Went first.
Karl, if you want to go first, it's also fine for me, maybe.
No, you can go first.
Okay. Because I think Safer Internet, the platform that was already mentioned before, is a very good example on how education in the digital world for children can work. I think it's getting to be more involved within the educational aspect in schools in Austria. So there are more focusing on the digital learning also in schools. We also have problems with that in a way, because then we have the problem of who has access, for example, to the digital world, and how is the access divided within our society. And who has to enable everybody to have access to the digital world. For example, within the Corona crisis, there was a big problem because the schools have to switch to the online version, and some children just didn't have any laptops, or just didn't have any access to the internet, and they got lost within the educational system for quite some time, I would say. So that's another aspect when it comes to education, the education of children within the digital world. And then that's the first thing, working with digital, with the digital possibilities. And the other thing is like, if you to enable them to live more and live better within the digital society, I would say that the educational programs really drive to enlarge the part of of this aspect that is taught in schools, but I would say there still needs to be more focus on that.
I mean, I can pick up on Nicholas' question whether it needs this or that, whether it needs education or regulation or whatsoever. I think both or everything is needed. No, we need to enhance digital literacy, media literacy of people, but I think at the same time we cannot do without some sort of regulation, which does not necessarily mean we need public authorities surveilling the internet 25 hours per day, but we would need some regulation of some sort, which can also be, or which is actually, that we start holding the platforms more and more liable. So it's not the state that controls everything, but like we hold the platforms more and more liable for what's going on the platforms. I think that's probably also a cheaper way to regulate. I guess that's it. That's a way why it is chosen. But so I think we do need all of them. I think we also need those kinds of ombudsman services, just like to we see ourselves as well as this as a seismograph. What's going on in the web? What kind of questions do people have? What are the issues going on at the moment, and to feed this back to the regulator. And I think you have to keep the threshold for asking those questions or filing such complaints as low as possible, and then just try to interpret those phenomena, or to communicate this then to the regulators, so that some sort of action can take place. But I think so. This is the point. I think education alone will not be enough, in my opinion.
Okay. Thank you so much, Karl. I would like to slowly come to an end by inviting everyone to give a final statement in the following order. It will be Veronika, then Sebastian, then Joerg, then Erich, then Karl, and finally, last not least, Annemarie. And Annemarie is going to collect all the questions and all the comments you might still have. So if you are listening to this and you want to add something which was not covered yet, this is your final opportunity as long as we are still live. After that, you can only complain in any other way. But at the moment, you can still influence directly what we are talking about. Veronika, please go ahead.
So on the final note, as a no-legal expert, let me give you some reflections with 3-4 more main points. First of all, don't look at users as objects. Second, when you reduce the digital divide, not just think about the access in terms of accessing the traditional infrastructure and the normative understanding of the interweb. When we talk about regulation, consider to regulate more from the perspective of the commercial enterprises. So what kind of financial aspects are playing out into these kind of harms we discussed before? And obviously, we cannot avoid the question of transparency and accountability, considering what kind of intent is played out in different socially, economically embedded online contexts. So for me, is engagement with more active democratization of online citizenship, independent from age, but more focused on the type of vulnerabilities of the digital society, which should change this kind of ecologies of our future environment. Thank you.
Thank you very much. Sebastian.
Thank you. I will keep it short because I think I already mentioned a lot of things. What I want to say is that it's important to really let children and young people participate. Also within this discussion, it would be interesting if children or young people can participate and bring in their ideas and perspectives. if we talk about vulnerable groups. And from a regulatory perspective, I would say it's important to really have in mind the best interest of the child if we work within this field, and really always have the children's rights perspective in every aspect that reflects on children and young people. Yeah. Thank you.
Thank you very much for this. I hope that Joerg will return. At least this is what I'm still expecting. So perhaps Erich would be the next one.
Yes, unmute first.
Well done. Better than me.
I'll keep it short. As you know, I'm a journalist and I'm not into policing. I'm not into policies, and I'm not in a position to propose exactly a thing or so. But what I take from this discussion, that my position, we need something of everything that was mentioned as a remedy, but it depends on the correct mix. And I can't go much farther, because I strictly refrain in my articles, their analysis, but I never ever wrote a line like politicians should be aware of this, should be aware of that. I don't do this. So don't expect much of me. I need to hurry up anyway. I need to go back to the roof of the Russian embassy to the UN, where I'm doing some pretty interesting. Well, it was fortune, luck too, but I've got high resolution pics and I must make them ready to publish. We will know what sort of dishes are up there, and after a while what they do. So this is my job. If you forgive, you're the policy people,
yeah,
and you're much more competent to to propose things. I just could jump in and say and tell a different aspect, or modify it, but not deliver a statement that looks like a possible solution. Thank you for having me.
Thank you so much, Erich, for joining us, and thank you for your precious time. That's very much appreciated. Very much looking forward to your article on the Russian embassy and what's going to happen there. Thank you so much. Jörg, happy to have you back, please.
Yes, same here. Sorry, my dishwasher demanded immediate attention with a lot of beeping. Yeah, I can relate to a lot of things that have been said before. Again, thanks for having me. My ideas coming from this panel is that we, of course, need protection of vulnerable groups. And like, for one example, in my law firm, we wrote an article on in-aim games and in-aim purchases on our blog, and now we have a lot of parents coming to us, and we have a lot of parents with who spend an amount of 5,000 euro, 10,000 euro, and actually we had one with 30,000 euros, which their 7-year-olds spent on in-app purchases. So my conclusion is that there are certain certain areas where we need hard regulation, also influencer, also social networks. But on the other hand, we have to be very careful, and chat control is a very, very, very good bad example for that, by not cutting down literally cutting down everybody else's basic rights on the net and in their private life. So do regulation, but do it carefully, and don't cut down basic rights by that. That is, yeah, I think that's my perspective, just to sum it up. Thanks for having me.
Thank you so much again, Jörg. Thank you for your time and all your input. I may hand over to Karl.
Yes, I can basically only endorse like the previous statements. As always in law, I think it's important to strike a fair balance between like the ends that we follow. So we actually at the end we have to find a balance between regulation and but not too much regulation at the same time. I think it's never a mistake to invest more into education. That means in every regard, so not only in digital matters, but in every regard. I think this is a very good investment. But still, I think in general, the IT community should not be too allergic against any sort of regulation. So I think there is just this tradition in the IT community to reject any kind of regulation or to reject any kind of proposals. And I think it would be like maybe more constructive to like to participate or contribute to finding this fair balance in order to reach these objectives. Like the protection of vulnerable groups.
Thank you. Wonderful, Karl. So last but not least, Annemarie, is there any more input from the audience?
Yes, we have one more question. It's on the online surveillance. So the question is the online surveillance of content that is marked as suitable for children not actually impinging on children's right to self-expression?
I think, Sebastian, this is probably going to you. You're muted.
No,
yeah,
thank you.
Now,
Now it also happened to me.
Happy, I'm sorry, but I'm happy that it's not me.
It's not so easy, even though it's only one button, but still.
Yeah.
No, yeah, I think there's again the balance between participation and protection. I see the problem also within the surveillance of content that is suitable or not suitable. I think you have to make, first of all, much of the work that is like to be done within the children's rights perspective is within their families, is within the schools, where children meet each other. So you have to be like from a preventive and also participative perspective, you have to work there and really talk to children what is important to mention or to be aware of when you go in the digital world. So that this kind of education can also be protection, also be like filtering which content is good and which is not good in a way. From a legal perspective, we have to be precise, because it's important not to ban children from the digital world. That's what I mentioned also before, which can happen if we ban too many websites. But on the other side, and also children sometimes need to make their own to live and grow and also make their own experiences. But on the other side, there are, as also said before, there is the necessity to protect children in specific fields and really make clear regulations on what is possible to view for children and what is not possible for you. So I think that would be the balance between participating and really protecting would also be here the right answer. Yeah. To make it easy for myself, because the right answer is always quite hard to give.
Thank you. Annemarie, I think that's it, right? Wonderful. So then thank you to all of you. I learned a lot. I really profited a lot and I liked it a lot. Thank you for all this and all your work on this. I may hand over back now to Peter if he is hearing me. And yeah, wonderful. So please, Peter, go ahead. Your floor again. Thank you.
Very much. This entertaining and enlightening panel discussion. Now, if you agree, we would take a screenshot from everyone from the panel. Annemarie will take the screenshot, or Hande. Do we have?
I just need 1 second. I just have to switch over to YouTube. Give me 1 moment.
Okay. So this time
I have a screenshot. I have one here. So
okay.
Thank you. Well, and unfortunately, although our event comes to an end now, and therefore I would like to ask from our department, Professor Dr. Iris Eisenberger, to close the conference.
So thank you very much. Can you see and hear me?
Yes.
Yes.
Yes,
yes,
great.
it works fine.
So thank you. I'm left with closing this highly interesting and very important IDLaw Conference 2022, which gives me the opportunity to thank the organizing team for first coming up with the topic of today's conference. Vulnerable groups are often not adequately regulated within European Union law. One of the reasons is that the EU not only lacks digital natives in its hierarchy, which we heard today, but also lacks adequate legal competences, which makes most of the EU legislation internal market driven and safety and security driven, often leaving aside other important issues, which is also true for the draft of the EU Artificial Intelligence Act. So thank you very much, first in alphabetical order, to Nina Hafner-Tomik, Annemarie Hofer, Matthias Klonner, Hande Özkayagan-Brendel, Mariana Rissetto, for all their work they put into this conference. We would also like to thank Catherine Altobelli, who helped gathering ideas for the conference topic and supported the team with first organizational steps earlier this year. But special thanks go to Peter Hübauer for his efforts in making this conference happen and leading us through today's event. Then, of course, thank you to all our speakers and panelists for their time and their great input. Also to our participants and the engaging and interesting discussion online. But last but not least, I would like to thank Nicolas Forgo for providing the room and the environment to have these kind of critical and much needed interdisciplinary discussions to develop new ideas, to train generations of students who are first digital natives, but who have both excellent legal knowledge, but also the necessary practical insights. So having said all that, I hope for continuous discussions on this very important topic, and I wish everyone a great remaining day. So bye to everyone.